Hello, everybody, and welcome to History / Law Bite number 210, dated March the 13th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History / Law Bite is entitled Plessy versus Ferguson, 163 U.S. 537, 1896. Plessy versus Ferguson, of course, is one of the most famous decisions in the history of the U.S. Supreme Court. Not for good reasons, though. Plessy is, of course, the Supreme Court decision wherein the court gave its blessing to state-mandated racial segregation of public facilities as long as those facilities were equal. Yes, equal in theory, but never ever in fact. From the Plessy case, the separate but equal doctrine was born, and it was indeed a doctrine that governed American constitutional law with respect to public accommodations virtually for the next 60 years. It would not be until the 1930s, in fact, some 40 years after Plessy, when the court slowly began to back away from it, slowly but surely, as a doctrine, and ultimately blowing up most of the foundation under it with Brown versus Board of Education in 1954. All right. And of course, subsequent decisions after Brown, as well as the Civil Rights Act of 1964 and other relevant federal laws, have all but erased Plessy's relevance as a precedent. All right. But indeed, Plessy's separate but equal doctrine was a very powerful one in U.S. constitutional law for many years. Okay. So, what exactly happened in the case of Plessy versus Ferguson? Well, let us time travel back to the 1890s in the state of Louisiana, whose legislature in the year 1890 had enacted a statute requiring separate railroad cars for white and for colored passengers. All right. Needless to say, this law was not popular, and it was even opposed by the railroad because, quite simply, it would cost a lot of money. The railroad would have to buy more cars. So naturally, they too were opposed to it. So the crafty folks in New Orleans, all right, specifically the Citizens Committee, all right, a local civil rights organization, engineered a test case to get this law either struck down or severely limited in its effect. So they organized this test case where somebody would get locked up for violating this law, and the process of challenging it through the courts would begin. So this very fortunate individual who offered to do it was a man by the name of Homer Plessy, who was a very fair-skinned African-American man, known respectfully as an octoroon, one who was 7/8 white, the remaining 1% being African-American. Indeed, Mr. Plessy was very, very fair-skinned to the point where he could have easily passed for a white man. And that was one reason that, he was ultimately chosen and volunteered for this mission, just to demonstrate how racist the law was in the state of Louisiana. All right. So Mr. Plessy indeed followed the game plan, purchased a first-class ticket, all right, and boarded the whites-only car. He was asked to move. He said no. Accordingly, the train stopped. Mr. Plessy was arrested and taken off the train, and charges were filed against him, thus beginning the legal process. So, Mr. Plessy was prosecuted, all right, and his lawyers argued in his defense that the Louisiana Separate Car Act violated his 13th and 14th Amendment rights under the U.S. Constitution. For the 13th, the law imposed a state of servitude on African Americans, and for the 14th, it obviously violated their equal protection of the laws. The trial judge, however, profoundly disagreed and ruled in favor of the state. And Mr. Plessy was ordered to pay a $25 fine for violating the law. An appeal was taken to the Supreme Court of the state of Louisiana, which the same arguments were made to as made in the lower court. The state contended once more that this law was perfectly legitimate as the cars provided were equal for blacks and for whites, and this is only a requirement within the state of Louisiana. Once again, Plessy's lawyers argued that his 13th and 14th Amendment rights were violated. The Supreme Court of Louisiana said, "We hereby affirm the judgment of the trial court." So therefore, they had lost at both the trial level and the Supreme Court of Louisiana. With that in mind, an appeal was taken to the Supreme Court of the United States, where the same arguments were made, of course, by Plessy's lawyers and by the state of Louisiana. Okay? So, the issue facing the Supreme Court of the United States quite simply was this: did Louisiana's 1890 law requiring separate rail cars for colored and for white passengers violate the 13th and 14th Amendments to the U.S. Constitution? In a 7-1 decision, the Supreme Court of the United States ruled that Louisiana's law was constitutional. Authored by Justice Henry Billings Brown, the Supreme Court ruled that Louisiana's law was in conformity with the U.S. Constitution and not in any way in violation of the 13th and 14th Amendments. Brown's opinion had four main points. The first point addressed the 13th Amendment. He said, quite simply, that the 13th Amendment was intended to abolish slavery and involuntary servitude except as punishment for a crime. All right? The law in Louisiana here imposes no state of servitude upon blacks. With that, he quoted a piece from the Civil Rights Cases of 1883, the opinion written by Justice Bradley, that it would be running the slavery question into the ground if every single instance of discrimination against blacks were viewed to be an imposition of servitude or a badge of servitude of some sort. So he killed that argument by Plessy's attorneys. His second point, quite simply, addressed the 14th Amendment. The 14th Amendment, according to Brown, quite obviously, was designed to enforce the absolute equality of both races before the law. But it was not intended, according to Brown, to enforce social equality or any type of commingling that was unsatisfactory to either whites or blacks. I think what he really meant to say there was unsatisfactory to whites because they were the ones that seemed to have the issue, not the blacks. But I digress. Okay? So after making this point, he says the 14th Amendment is not designed to enforce social equality. Okay, fine, whatever. He then moves to cite several state court decisions affirming racial segregation. I assume this is to let the reader know that racial segregation has a long history in this country, and indeed it does. But the problem with the citation of those cases is that virtually all of them, if not all of them, were decided well before the adoption of the 14th Amendment, and they are therefore not germane to this case. Again, I digress. All right? So, being that the 14th Amendment was not intended to enforce social equality, he hit that part of Plessy's attorney's argument, all right, knocking it off from consideration. So his third point was that the Louisiana law was a reasonable exercise of the state's police powers, okay? These are, of course, laws designed to regulate the health, welfare, and morals of the people, all right? Essentially, according to Brown, as long as a law was not designed to oppress or annoy a particular group of citizens, it would likely pass 14th Amendment scrutiny. And he cites an example of what he means by designing to oppress a group of citizens with the case of Yickwo versus Hopkins, decided 10 years before Plessy. all right, where a San Francisco ordinance, was, while neutral on its face, was deliberately designed to exclude Chinese workers from the laundry business and thus openly discriminate against Chinese workers in its practice. The application of that law was very discriminatory. Neutral on its face, discriminatory in practice. So according to Brown, as long as the law wasn't operating like that, or blatantly assigning, an inferior status to a particular group, it's likely going to pass 14th Amendment scrutiny, as was the case here with the Louisiana law, okay? And last but not least, the Louisiana law, as argued by Plessy's attorneys, imposed absolutely no badge of inferiority on the colored race, all right? Certainly not by the language of the statute itself. If the law does indeed impose a badge of inferiority on the colored race, it is because the colored race has chosen to put that construction upon it, all right? So these are the 4 points that Brown makes in his opinion that essentially have the most relevance, all right? So the 4th point, Brown is simply saying, black people, it's all in your head. The law is very fair. It's very logical. And if you want to think that it's, classifying you as inferior, then that's on you. It's all in your head. The law is not saying you're inferior, all right? With that, I would like to read the final statements of his opinion, which you will probably find interesting. All right. It says, when the government, therefore, has secured to each of its citizens equal rights before the law and equal opportunities for improvement and progress, it has accomplished the end for which it was organized and performed all of the functions respecting social advantages with which it is endowed. Okay? Legislation is powerless to eradicate racial instincts or to abolish distinctions based on physical differences. And the attempt to do so can only result in accentuating the difficulties of the present situation. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them on the same plane. That's pretty deep. Therefore, with that in mind, the judgment and opinion of the Supreme Court of Louisiana was affirmed, and that these separate railroad cars soon grow to be many more things than that, but these separate railroad cars for colored and for white citizens in their state as being equal were therefore constitutional. Judgment of the Louisiana Supreme Court affirmed. So then, we then see the dissent by the great John Marshall Harlan, who rips into Brown's majority opinion with no mercy. Justice John Marshall Harlan totally disagreed with Brown's majority opinion and asserted that the law had the clear intent to impose a sense of inferiority among African Americans. The intent was not so much to keep whites away from blacks, but rather to keep blacks away from whites. All right? And essentially only an ignorant fool would try to suggest anything to the contrary. Harlan wasn't biting his tongue here. He argued that even if some considered themselves superior to others on account of race, the Constitution of the United States had a very different tone. All right? Harlan wrote, and I quote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are involved. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by citizens of their civil rights solely upon the basis of race. Okay? In other words, to Harlan, the Constitution would not and does not allow racial segregation. All right? The 14th Amendment's language is clear. Equal protection of the laws. Okay? And racial segregation is a concept that clearly runs contrary to equal protection of the laws. All right? Harlan takes no prisoners. All right? And he very accurately prophesied that the Plessy versus Ferguson decision would go down in history as one of the court's great mistakes, to say the very least. Just to be just as nefarious as Dred Scott. And lo and behold, Plessy has indeed earned that reputation. For the record, Dred Scott was handed down exactly 40 years before Plessy versus Ferguson. All right? Both decisions are in the court's horrible mistake file cabinet. And indeed. All right? So that was the judgment and opinion of the Supreme Court in Plessy versus Ferguson. Okay? And of course, the effects of this decision quite naturally were profound. With the Supreme Court's blessing, segregation, which already existed in certain areas of public life in the South and in the North, soon grew to include virtually all areas of public life in the South and in many more areas of public life in the North. The primary difference was that in the South, you knew exactly where you could go and where you couldn't go as an African American or a member of another racial group, such as Latino or Asian American. All right. Whereas in the North, you might find yourself embarrassed in front of a large group of people because the North had de jure segregation, quiet, low-key segregation for the most part. Whereas in the South, colored only, white only. All right. Make no mistake about it. If you're not white, don't come in here. All right. And of course, the concept of sundown towns, where if you were not white, you either better be indoors or, better be out of there by sundown, one or the other. That concept is still very much alive today. Okay. So the effects of Plessy, were very real and very powerful. And like I said, this decision, all right, was not upended until Brown versus Board of Education in 1954 for the most part. But several decisions, as I said earlier, beginning in the 1930s, certainly weakened the force that Plessy had upon the ability of states to segregate individuals in the public realm. All right. So that's Plessy versus Ferguson. Any questions or controversies, leave them down below, and I'll be happy to answer them. Before I go, though, I just want to point out a couple of more ironies from this case. You might think this decision came from a Supreme Court dominated by Southerners, but you'd be wrong in your thoughts. John Marshall Harlan, who wrote The Magnificent Dissent, was only one of two Southerners on the Supreme Court in 1896, the other one being Associate Justice Edward White, who joined the majority, unfortunately. But his reputation has fluctuated through time, being that he did, in later years, rule against many white supremacist practices, such as grandfather clauses in voting, okay? And also, Harlan himself had once been a slaveholder, all right? So to hear him speak so embracingly with respect to equal protection of the law as a man who once was a slaveholder is nothing short of phenomenal. All right. So again, any questions or controversies, leave them down below and I'll be happy to answer them. If you enjoyed this video, which I hope you did, drop me a like. It would be greatly appreciated. If you have not subscribed to my YouTube channel, just hit that little red subscribe button right there. I would certainly appreciate that more than anything in the world. And if you'd like to donate to my channel financially, links are provided on the main page. Again, thank you so much for listening if you made it this far. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.